Within the past few weeks, the Trump administration has ended the parole program. It has also announced that TPS will no longer be for Venezuelan immigrants as well as Haitian immigrants. This is devastating because these are immigrants who were allowed to come into the country legally based on the devastating and dangerous and destabilizing conditions in their own countries. Now they are at risk for being deported. But here's the thing. There are options that may be available for those who have been here on TPS, who are here on certain parole programs, and who have also been on DACA, because DACA is also now on shaky ground since the program has been invalidated by a court in Texas. So, what can work here is employer sponsorship based on Section 245K. If you entered the country with permission, that means you entered with a visa or you were paroled into the country, from the time you entered up until the time you were granted protection here in the United States, you were never out of status for more than 180 days. It means you can still qualify for the employment-based green card. And the good news is that you'll be able to apply for the employment-based green card based on Section 245K without leaving the United States. Stay with me in this video because in the course of this video, I'm going to take step-by-step approach to how this can be done for you. I'm U.S. Immigration Attorney Sharifa Tharpe. I help immigrants to stay here legally, and I also share updated information and legal strategies with immigrants in order to empower them through their immigration journey. Don't forget to like, subscribe, hit the notification bell so that you never miss an update and that more people know about this information that can continue to empower them. So step 1, let's look at how we can use Section 245K to be able to get you to adjustment of status in the employment-based green card process. It is a part of the immigration law that allows you to still move forward with the employment-based green card and adjustment of status if you have not accrued any unlawful presence over 180 days. Now, who qualifies for this? You need to be eligible for an employment-based green card. That means that an employer is sponsoring you, or you may qualify for the EB-1 Extraordinary Ability Green Card or the EB-2 National Interest Waiver Green Card. There's also the EB-3 Green Card that requires employer sponsorship. You also have to show that you have not been out of status for more than 180 days. And that's 180 days since your last lawful entry. If you can show this, then it means that you do have a chance at adjusting status and you don't need to fall under any other provisions like 245I where you have to show a previous petition was filed. You just need to have the employer sponsorship or qualify for an employment-based green card where you can apply for yourself. Step 2 is to use your TPS or your DACA status to be able to apply for this. Here's how your TPS or your DACA status would be able to help here. If you enter the country without permission, but you were granted advanced parole that allows you to now show you were paroled or given permission to enter the country as a TPS holder or as a DACA recipient, or if you legally entered the United States with a visa, even if that visa has now expired, then that would be one way that you would still be able to proceed with Section 245K along with showing your legal entry. Once again, in this process, you have to show that you have not been out of status for more than 180 days. Under these conditions, if an employer is willing to sponsor you or you qualify for a self-petition under the employment-based categories, it means that you have a shot at getting adjustment of status, getting the green card while staying in the US. And this leads me to step 3, which is to look at your employment-based green card options. If you're a DACA recipient or you also have TPS, you may have been here for a long time, and an employer may be willing to sponsor you. In addition to that, you may have gained education and qualifications that now qualify you to apply for Extraordinary Ability Green Card or the Exceptional Ability National or National Interest Waiver Green Card. So here's where you really need to seriously evaluate your options and have that conversation with your employer at this point to see if they're willing to get involved to help you to stay here legally in the United States. It's important to weigh these options now while these options are still here. Now, I know the next question that's coming. If you've been out of status for more than 180 days, then what options are there? Yes, if you have been out of status for more than 180 days, that Section 245K for the employment-based green card adjustment of status process will not work here. But here's where it's very important to consider your other options. Consider your family-based immigration options. If you are the immediate relative of a U.S. citizen, that means you're the spouse of a U.S. citizen, you're the parent of a U.S. citizen who's age 21 or older, or you are the son or daughter who's under 21 and unmarried of a U.S. citizen, then you may still qualify to apply for the green card even if you've already overstayed your visa. But say you came into the country without permission and you don't have advance parole to show any kind of entry into the United States, then it's time to look at the I-601A waiver to help to forgive the overstay if you're going to apply for family-based or you're going to apply for employment-based green card process. The I-601A waiver does not lead to adjustment of status, but it does offer you some protections while you're here in the United States, and then you would be able to get permission to leave the country, go to your interview at the embassy, and come back with an immigrant visa to get your green card. And then there are humanitarian options. I would say this: if you've been abused, mistreated, exploited in the United States, it's time to give us a call to talk about your options here, because you may qualify for relief as the victim, and you definitely want the government to know that you're the victim here. Now, this is going to definitely take legal strategy, attention to detail to make sure you could qualify for relief under Section 245K. So here's where I'm urging you to treat this with urgency. Schedule an appointment with us so we can get started ASAP. You found this video helpful? Make sure you like and subscribe so others will be able to see the video and be able to get information that can empower them through their immigration journey. Also, don't forget to hit the notification bell so you never miss another update.